I do not find it hard to believe that these specific attorneys didn't know someone else was being prosecuted. Now,
let's roll, nerds.
Judge Boyd is already looking at the attorneys when she asks the question. The courtroom is mid-trial. The jury has not yet come in. A man named Duran Evans is on trial, and the proceeding is about to stop completely.
There's a video, the first statement made by the complaining witness when she comes to the police office is recorded, and that was tendered in discovery. I was under the impression that it was one of the officers who made a report.
The problem starts with a body camera video. Defense attorneys have a clip, roughly 90 seconds long, of the complaining witness making her first statement to police at the station. When they go to question the officer they believed filmed it, she tells them that camera is not hers. She does not know who filmed it. The audio on the clip cuts off before the witness finishes speaking.
Asked her, because she wrote the statement that she's the one that met. So I said, here, will you have her review this 1 minute, 30-second body cam, just so we can...
So what's the issue?
The issue is, she says, well, that's not me. I think it's these two other guys who were mentioned nowhere in the reports. And in the video, she starts making a statement about what happened to those officers, and then it cuts off. So I don't know who those officers are. I don't know what that statement was. There's no way I can properly impeach her.
Defense attorney Sidgree tells the judge what this means in practice. The complaining witness has made at least 3 separate statements over the course of this investigation. Each one may be different from the last. Inconsistencies between statements are a core tool of cross-examination. If the defense cannot identify who filmed statement 1, they cannot call that officer.
Well, my issue is that they've got officers they want to bring who heard a second version, a third version, a fourth version. They're saying that's not us that heard that first version that you saw on video that got cut off.
And they can't talk about that.
But how can they even talk about what she told them? Because I'm not able to impeach any of these witnesses if I don't have all of their statements that the state has. And I don't have the same knowledge that the police department has. Since they took these statements, that first statement might have tons of impeachment in it that I can use again.
If they cannot call that officer, they cannot question the witness about what she said that day. If they cannot do that, they cannot properly challenge her credibility at trial. This is not a procedural technicality. This is the constitutional right to confront the witnesses against you. The prosecutor, Dig Sanchez, tells the court that everything in the state's possession has been disclosed to the defense. The report is complete. The evidence is complete. Nothing is being held back.
Against Sinani, but I can use against...
So why is everybody waiting till the last minute to talk about a first statement?
To the state's knowledge, there are no statements that have not been disclosed to defense. Everything has been documented in the report and has been provided to defense.
So here's my question. Has the first statement been provided?
Judge Boyd asks a simpler version of the question. Has the first statement been provided to the defense? Sanchez says yes. The judge asks whether the only remaining issue is identifying which officer filmed it. The defense says that is not a small issue. Gry explains the problem more precisely.
Hold on. What it is, Your Honor, is that the statement was stopped in the middle of the body cam video. The statement's done. So we were thinking, because the impression that we got, it was from this one officer who was going to be testifying. So when we go to question her and we were asking her questions, it's basically saying, oh, that's not my body camera. That wasn't me. I don't know what happened at that point.
She didn't know what that statement was.
So she doesn't know anything about that statement. So, and the statements have been changing throughout. So we want to see how far the statements have changed from statement number 1 to statement number 2 to statement number 3. If we're just finding out today that statement number 1 wasn't even taken by the officers who we believed it to be, we can't properly impeach. If they can identify who that officer is, then we can bring them up and testify, well, what is it that she told you in statement number 1? But we can't even do that because they've not been identified.
The body camera footage exists. It shows the complaining witness beginning to give a statement. Then the audio stops. The footage ends. Somewhere in the gap between when that camera turned on and when it went silent, the witness said something to a police officer. That officer wrote no supplemental report. That officer has not been identified. That officer may not even know they are relevant to this trial.
Just 1 second. So number 1, I do not find it hard to believe that these specific attorneys didn't know someone else was being prosecuted. Now, are they supposed to have constructive knowledge? That's completely different. But as far as them having actual knowledge that he was charged with an offense and that it is in this courthouse, necessarily they wouldn't have an actual knowledge of that. And how many prosecutors, when you're running criminal history, you actually run the criminal history of officers? That's usually never done. So I understand that
She orders
constructively
both sides
they
to
should
step
have
back,
known,
talk to each other,
or constructively
and return before the
they
jury
do
walks
know,
in. They come
but
back
they
2
didn't
minutes
have
later with
actual
more
knowledge.
confusion
Did you
than
have
clarity.
actual knowledge?
The officers present,
Judge
in the
Boyd
building are
snorts
Officer
once.
Cavedo and Detective
She tells
Hands.
everyone
to stop talking over each other. She says she cannot rule on anything if she cannot hear anything.
I cannot make a proper ruling if everybody wants to converse over each other. This is the information I need and this is the information I want. And then you can all do your arguments afterwards. So the first statement, and I'll just call
Neither
it
of them
first
is the
statement.
officer on the body
And
camera
that was by the
footage.
complainant.
The officer whose name
Who
keeps
is the
surfacing is
officer
Officer
who
Kennedy.
took the first statement? All right, I'm gonna have y'all step back. Y'all discuss whatever y'all want to discuss, then you come back. But the jury is coming in like 5 minutes. And if y'all have not finished,
No, that's not correct.
But
The
Officer
second
Kennedy is
statement
not in
was
the building.
made at the station
Officer
to
Kennedy
some
was not
mysterious
subpoenaed by
police
the state.
officer who had the body
The
camera.
state had
And
planned
the
to
body
call him
camera,
on that
as she
meeting.
starts to talk, it
Judge
goes
Boyd
off.
asks the officers
Now,
who are
the questions
present
that we
to meet
have
with
is,
both
what did she
attorneys
tell
in
that
the back
officer?
to see if they
And
can
why? And
identify
we
whose
had that
camera
officer
recorded the
to ask the
footage.
officer,
Is
why do you
there-
feel the need
Officer
to turn off
suggests
your
it might
body
be a
camera?
Is there a
Corporal
statement?
Lee or an Officer
So,
Brian Smith.
what his-
Another thinks it sounds like Kennedy. The judge dismisses the jury for the day and tells everyone to be back by 10 o'clock the next morning with answers.
let me ask you this. Are
Then
these
the
officers
second
here?
thing happens.
Yes.
During
Officer
that
Caballero
hallway
and
conversation
Detective
between the attorneys and the
Jimenez are here.
officers, someone mentions
Kennedy.
Officer
Bring them down.
Kennedy's name.
And they will come down and you all talk to them. All right, thank you.
Officer Kennedy, though, is not here, and that's the person that we wanted to talk to and find out who the other officer was. We're getting you.
And someone else knows something. The defense attorney comes back into the courtroom and informs the court that Officer Kennedy was charged with aggravated assault by a public servant. He was prosecuted by this same district attorney's office. He pled out on Monday, 2 days before this moment. He is awaiting a pre-sentence investigation scheduled for January 28th. The prosecution in Officer Kennedy's criminal
We,
case
as of
was
right
handled
now,
by the
have
same
no
office
reason to
now
believe
prosecuting
that body
Duran
cam belongs
Evans.
to any
The
other
hearing on
officer
Kennedy's
other
plea
than
took
Officer
place in the
Kennedy's.
courthouse directly
Still
underneath this
trying to
courtroom.
confirm it through superiors
The
over at
defense
the
was
Live Oak
never
Police
told.
Department.
Sanchez
No
tells the
information's been
judge that
provided
under
to
the
us that
state's
would lead
reading
us to
of its
believe that it is
ethical
anyone else
obligations,
but Officer
disclosure of a witness's
All right,
criminal
so here's
case
my other
is
thing.
not
So is
required until
Officer
a conviction
Kennedy
is finalized.
subpoenaed to testify in this
Kennedy has
case?
not
He was
yet
not
been
subpoenaed by the
sentenced.
state. He was
The
not the
conviction
witness
is
state was
not
planning
yet
on
final.
call.
Therefore, in the
Okay,
prosecutor's
so
view,
I'd
no
say she
obligation
should
to
subpoena
disclose has
if
technically
needed for
been
him.
triggered. Judge Boyd does not agree with the framing. She says the question is not whether they were required to disclose.
All right, so the state is going to want him to be here. So y'all will need to contact Mr. Kennedy's attorney. So I'm going to excuse the jury. They're going to be back here tomorrow, and you all need to be here by 10, and you need to have all the information, be ready to proceed.
Sure.
Thank you.
All right, thank you.
The next morning.
The state is imputed to know this information, whether it's actual knowledge.
Pauses on that. She says she finds it genuinely difficult to believe that any specific attorney in that office had personal knowledge directly, whether he had actual knowledge of Kennedy's criminal case in that same Sanchez says he did not. District attorney's offices are large institutions. Prosecutors carry heavy caseloads. One prosecutor does not necessarily know what another prosecutor is doing on the floor below. She is willing to accept that Sanchez himself had no actual knowledge, but she draws a line. Constructive knowledge is different from actual
But
knowledge.
shouldn't they have been made aware in the spirit of the law and what they should be told? That your witness,
Yes, and as soon as we became aware of it, it was disclosed.
I find it hard to believe that this district attorney's office is not aware of a person that they're prosecuting in the courtroom directly underneath this one.
It wasn't disclosed to her. 30 seconds.
Was on the
Just-
Medicaid.
just one
Constructive
second.
knowledge is what
So
the
number
law
one,
presumes an institution knows
I
based
do
on
not
what it
find
has
it hard to
access
believe
to.
that these
The
specific
district
attorneys
attorney's
didn't
office
know
is
someone else was
prosecuting
being
Officer
prosecuted.
Kennedy.
Now,
The district attorney's office is also
do they
prosecuting
have,
Duran Evans,
are they sup-
and Officer
supposed to have
Kennedy may be a
constructive
witness in that
knowledge?
case.
That's completely different.
The institution
But
has
as far
access
as
to
them
both files
Having
simultaneously.
actual knowledge
Whether any
that
individual attorney
he was
looks
charged
is a
with an
separate
offense
question.
and
The
that it
judge
is
asks
in
the prosecution to
this
contact
courthouse,
Kennedy's attorney. She orders both
necessarily
sides
they
to
wouldn't have an
determine
actual
whether
knowledge
they
of
want
that.
Kennedy
And
subpoenaed to testify and whether they want the
how
video of the
many
complaining witness speaking to him
prosecutors,
excluded
when you're
from
running
trial.
criminal history,
She brings the
you
jury
actually
back the next
run the
morning
criminal
with those
history
questions still unresolved.
of officers.
The
That's
next
usually
morning,
never
Kennedy
done.
has not
So
responded.
I
The state has
understand
notified him.
that
He has not
constructively
answered.
they should have
The
known,
defense says the state
or
knows how to reach
constructively
him.
they do
Kennedy
know,
has been in this courthouse
but
recently.
they didn't have
He has
actual
an
knowledge.
attorney.
Did you have
He has
actual
a pending
knowledge?
sentence date. The state has processed servers available. The defense wants him served that morning so he can testify that day.
Did not.
All right. So he doesn't have actual knowledge, but he has constructive knowledge.
But Your Honor,
All right.
but Your Honor,
All right.
Your Honor, we still don't know who the actual officers are.
Late.
Judge Boyd tells both sides they need to decide. Do they want the video excluded? Do they want Kennedy on the stand? She will take up either question when it is properly presented.
Yeah,
Do you want Mr. Kennedy here?
Everyone here, they stated that they can't get a hold of him. Your Honor, he was in this court, the state knows how to get a hold of him, ask them here for pretrial services to do this.
Okay,
I'm asking the state and asking the court to notify the state.
All right, so here's my question with Mr. Kennedy. Do y'all want him to be excluded from testifying or not? So that's what,
I want him here to testify. I want him subpoena. What I asked the state to do is that they have pre-trial services on that say, hey, show up today and you can get served right then and there.
all right, so I
And
don't
they know where he lives. I mean,
So my
exposes
question
something
is that I want
structural
everyone
about
to
how
consider, and I'm
information
bringing the
moves
jury in.
inside a prosecutorial
My question is,
institution.
everyone needs to make a
The state is
determination.
not a single lawyer sitting across from
now,
a defendant.
the trial moves
It is a
forward.
bureaucracy
What this
with
case
hundreds of
reveals is
open
not
cases,
limited to the facts of
dozens
Duran
of attorneys,
Evans's trial.
investigators, police
All right, so with
departments,
regards to
and databases that
the
do not
statement that was
automatically
made to
communicate with each
Mr.
other.
Kennedy,
When a police
whether or
officer
not
who
that
may
will
be a
be
witness in case A
excluded,
is also being criminally
we'll take that
prosecuted by
up
the same office in
if
case
it is
B,
offered.
no
With
automated
regards to
system
any
flags
other
the overlap.
statements that the complainant has
No
made
procedure
to
requires
anyone,
anyone to check.
that's going to be subject
The
to the rules
obligation
of
to disclose
evidence
falls on individuals
and
who may never know
whatever
the connection exists.
objections people may
That is
have.
how a criminal case against a
I'm
police
sure both
officer
parties
can be
are
processed,
aware that
plea,
some
bargained,
statements are
and scheduled for
out-of-court
sentencing
statements that
in
are
a
not
courtroom
sworn to.
directly beneath
So the
an
court
ongoing
will
trial
take that
where
up
that same officer is a potential
as
witness
it is presented.
without anyone in that office ever connecting the two. Duran Evans's defense attorney discovered this not through a disclosure, not through a court filing, not through any mechanism the system designed for this purpose. He discovered it in a hallway conversation about a body camera. The question the judge raises is the one that remains. Actual knowledge and constructive knowledge are not the same thing. But when the gap between what an institution knew and what it disclosed is large enough to alter the outcome of a trial, the distinction between them stops feeling like a legal technicality and starts feeling like something else entirely.
Do they want him excluded from testifying? Do they want any video where the complainant was speaking to him excluded? You all need to let the court know that, and the court will take that up. But for now, just seek to have him subpoenaed. State versus Duran Evans. Could I have parties announced for the record?
Daniel Diego Sanchez for the state.
Sid Greehey for Mr. Evans.
Yes. So where are we?
So we discussed this with the two witnesses, the two officers in the back. The female officer gave two names. She thought that it might be a Corporal Reese or an Officer Brian Smith. The gentleman officer said that he thinks it sounds like Officer Kennedy. We just found out right now that Officer Kennedy was charged with aggravated assault by a public servant in this courthouse, being prosecuted by this district attorney's office, which we were not made aware of until just right now. He apparently pled out of the 226 on the 1st, which was Monday. He's sentenced for a PSI on the 28th of January. We're just finding this out.
You want to